SJC-13713, Commonwealth versus Pierre, Cadet.
Okay, Attorney Schnipper, good morning.
Good morning. Excuse me. Good morning, Chief Justice Budd, and may it please the court. Happy New Year to everyone. Merritt Schnipper here today representing Pierre Paul Cadet. Evidence is material to identification in a Chapter 278A self-defense case if it tends to support the inference a defendant acted lawfully. That can mean showing that the alleged victim was actually the first aggressor, or it can mean demonstrating that the defendant did not behave in a manner consistent with guilt. The testing the defendant requested in this case in his pro se filings has the potential to produce both sorts of evidence. Handler DNA analysis that showed Bettina Francois held the knives in question before the defendant did would support his trial testimony that she initiated their fatal confrontation.
So how does the appearance, let's just assume the test results come in and show that she handled the knives, how does that inform whether she held them first?
Well, it does not definitively answer that question for sure.
Does it even contribute to that? I
think it does, because what I think it shows is that there was already DNA testing on the handles of the knives on portions that are bloodstained. So by inference, that DNA was deposited after a fight began. So we get to the part that's not bloodstained, which the handler swabs were seeking to test. The question then is, who was holding those knives at a time where there wasn't going to be blood deposited on their handles? And that would corroborate Mr. Cadet's trial testimony that when the fight began, he turned around as he was trying to leave the apartment. He saw her standing with a knife in each hand. He tried to move past her. She stabbed him in the throat, and that's when they fell into fighting. So it would support the inference that she was the first aggressor, because let's go all the way and assume that it's only her DNA on those unstained portions of the knife handles. That would support an inference that all DNA of Cadet's was deposited after the fight began, whereas there was some Francois DNA deposited before the fight began, thus supporting his testimony that she had begun the fight by attacking him with a knife again.
So that's just our common sense?
I think so. Well, I mean, it's common sense, but what it really is if we're talking about being able to challenge the Commonwealth's narrative at trial, we're talking about being able to argue an inference to the jury that because one person's DNA is on the part of the handle that didn't have blood on it, it was deposited before the fight started. And I would point out that that's actually part of what defense counsel argued in his closing at trial, that because only her DNA is on one of the knives, that supports the idea that she started the fight. Of course, he was corrected by the Commonwealth in its closing, said, don't forget that the forensic scientist from the lab testified that all that DNA was deposited from blood. It doesn't tell you about who picked up the knife first.
I'm sorry. No, please go ahead.
So I want to focus on the actual trial testimony. I saw two experts who testified that the handles were swabbed for handler DNA.
Were?
Yes, were in volume 5.
Mm-hmm.
I take it. So why are we here?
We're here because Mr. Cadet would like to test those swabs, and they were never run before trial.
But there is actually testimony that says, or at least suggests, that they were, and there was no handler DNA located.
Well, what she says is we gathered for purposes of testing for handler DNA, but we never performed those tests. And then she does say,
can you point me to where it says they were never tested for the handler DNA? Because I didn't see that in the transcript. Can you give me a transcript reference for that?
I cannot give you a pin site for that.
Because I don't think there was one that said that. And what I do see is two experts who testified that the handles were swabbed for handler DNA, and one who says, I didn't see any handler DNA on it, the actual person who did the testing. Assuming it's a fair inference that that means they didn't see it because it wasn't there, how does this situation even fall under Chapter 278A? Because I don't think it gives you a second chance to redo tests that were already done.
Well, it does if there's improved technology, but that's not what we're talking about here. Because her testimony is that we swabbed it, and then she goes through the testing that was performed, and she never talks about testing those swabs. I think that creates a fair inference, at the very least at the Section 3 stage, that they were not tested, right? There is, when you look at the criminalistics logs that Mr. Cadet put in his pro se filings, there's no results brought out from the handler swabs. There's only results brought out from the blood swabs.
There, one of the experts testified that when they swabbed the areas for handler DNA, they didn't pick up anything that didn't have blood in it, even though the blood was not visible to the naked eye. So did you see that testimony?
Well, I mean, I saw lots of testimony about them searching for occult or non-visible blood, for sure, mostly about the cleanup of the floor area. But what she specifically says is we swabbed the handles for potential handler DNA later. And then in her testimony, she says, I saw no signs of handler DNA in this case, but that does not in any way suggest that the test was performed and it came out without the presence of handler DNA. That's the first question. And obviously, I'm here on a pro se motion, so I didn't draft it below, so apologies for that. But that would that would then actually beg the question of whether, in fact, there was, assuming that they didn't detect anything back in 2004, 2005 range, that here we are 20 years later, there very well is, we know, based on probabilistic genotyping and all the technological advances, there actually are tools that could get more specific on that handler DNA. So again, it's an imperfect filing, but I would suggest the fact that there were handler swabs and there is no affirmative testimony about the testing of that for nothing, producing nothing, means that there is something to do at the Section 3 stage. It sounds like there would be a very legitimate subject of discussion about what testing was done back then and what possible improvements could happen now if we went to a Section 7 hearing, which is what we think is the appropriate treatment of this motion here. Just, again, this is not, there's nobody's getting over a goal line here. This is simply to pass through the most minimal threshold initial stage, right? I mean, one of the problems here, and this is both a factor of, frankly, the judge's treatment of the motion and the fact that it wasn't presented in a way that was most effective to bring the salient points to the court's attention. But one of the problems here is we've been stopped in our tracks at the very preliminary stage. And the fact certainly is that his testimony at trial describes her holding a knife in both hands and him turning around and seeing that. There's no question about that. And the testimony at trial talks about the collection of handler DNA swabs, right? And there is no affirmative testimony about their analysis. So I think—
I realize that it was an imperfect filing, but it was the filing that was before the judge who ruled on it. So, and so in that filing, what I understood the thrust of the motion to be was that the experts who testified, or the chemists who testified at trial, gave false testimony.
That was about the cleanup, the scene cleanup.
That was not about the handler DNA?
No, I mean, the handler DNA, I mean, there's really the two claims here, and it's my opinion, I mean, obviously the court's going to be the ultimate arbiter of this, that the handler DNA is a very straightforward, appropriate Section 3 claim, right? I mean, it's just like, she held it, there's no affirmative results, there's still swabs out there, let's test them. That's kind of the most straightforward Section 3 claim I've ever seen. And the court has repeatedly said in cases like Randolph that the fact that someone held a knife on the day of the crime is sufficient to justify testing. So I think we're there. Then the question becomes, with regard to the false testimony, right? He was talking about testimony that implied that because occult blood was found in areas that appeared to not have blood on them, that was indicative of forensic testing that showed he had attempted to clean up. And that gets over to his attempt to test cleaning materials to show that he did not, in fact, attempt to clean the scene. And that's where he gets, to trying to rebut the Commonwealth's inference.
That claim of false testimony at trial seems to me closer to be Rule 30 territory than Chapter 278 territory.
Well, I mean, I think, let's think about the cleanup claim in two sections. Let's imagine he never testified for a second. Obviously, there's a bottle of bleach there. The Commonwealth says, look, he brought this to the scene and tried to clean up after the fact. That shows he was guilty. He says, no, I never brought it there. Obviously, that would be a straightforward claim to test that bottle and see if he ever touched it. It might not be strong evidence, but it's something that could be tested. His statements, while it's a novel and interesting question, I don't think it gets us into Rule 30 territory because the statute specifically addresses the idea of challenging your own statements through forensic testing, right? It says if you've pled guilty, in other words, you've said previously, I was properly identified as the perpetrator of this crime, I can now come into court and say forensic testing will show I was not properly identified. Right? It also says if you've made an incriminating statement, you can seek testing to contradict that, or at least in the face of that incriminating statement. Here, what we have is a statement made in the course of asserting one's innocence, but which certainly was able to be treated by the government as arguably incriminating. And of course, that's what the statute says. If you made a statement that is incriminating or could be interpreted as incriminating, you still can file a motion under this chapter. So certainly getting into the credibility assessments would have to be made. Well, you previously said this, and now you say you didn't do it because you've got forensics that say this. That's certainly something that would be a powerful issue to have to deal with at the Rule 30 stage. But I don't think it means that the issue of challenging that testimony by obtaining forensic testing in the first instance has to be done through the Rule 30 process. Because I just think that the language of Chapter 278A specifically says go ahead and get some forensic testing, even if you've made a incriminating statement. I think the import of that has to be that even if you've made an incriminating statement that appears to that the forensic testing you're seeking would be in contradiction of, right? I mean, that's because in the sort of paradigmatic case where you say, I didn't do it at all, I was across town, but you pled guilty earlier, and now you're coming in saying, wait, this forensics will show it wasn't me, right? You're doing it in the face of previously having admitted committing the crime. So any subsidiary statement, well, I didn't commit the crime, but I did do this thing that the government says is indicative of consciousness of guilt, I still think you can come in under Chapter 278A and seek testing in the face of that statement, because I just think that's what's permitted by the plain language of the statute.
Attorney Schnipper, could I go back to Justice Wendland's earlier question, because I'm still struggling with this. So if the idea is that Cadet testifies that he turns around and he sees her with both hands, with knife in both hands, and the issue that you're looking to at least corroborate is the first aggressor, right?
Yes.
But I thought that wasn't there testimony that he hadn't been living in the unit prior to coming over there that night?
Well, there was testimony that he was living there off and on. Well, first there was testimony that he was living there. Then there was testimony that he moved out and there was restraining order proceedings. And then there was testimony that he had been spending nights back there. And then, of course, his own testimony was that he spent the night before the crime at the apartment.
So I understand what you mean about that you can't collapse whether or not it would actually have any probative force at trial at this stage. But to the extent that these are knives, I mean, I know the Commonwealth raises this, but not necessarily just when it was that she touched these knives, but the fact that she was probably, you would find her touch DNA on this. So how does that advance the ball, so to speak, to the first aggressor theory that you have, that there'd be handler DNA on the handles of two knives that were found in the kitchen of the woman's home. Right. So I'm just trying to understand, because it's a really difficult. I know what you're saying, that you don't get into what Judge Sullivan might have done here, be like, look downfield to what it was, how it's going to play at trial. But how do we necessarily do this without considering that?
Well, I think you just isolate the materiality inquiry from the strength of the evidence inquiry.
But I think just on the materiality point, how could it be material to the first aggressor theory if there's handler DNA on her own knives?
Well, it's just, I think, because, like, let's imagine it this way. Let's think about a situation in which they looked at knives from her kitchen and only his DNA was on there. We'd be treating that as evidence of guilt, notwithstanding the fact that he was a frequent occupant of the apartment as well. I think what's going on here is that we have a purely circumstantial first aggressor case from the Commonwealth. We have prior bad acts, we have flight, we have other things that appear indicative of, oh no, you didn't, even though you say you were attacked, you were actually the attacker here. And what the court said in Ramos is, forensic corroboration is particularly significant in cases where the Commonwealth's first aggressor case is based solely on circumstantial evidence. So I certainly agree that there's a powerful argument once you get to the trial prejudice stage that, hey, everybody, what do you expect? This is Miss Francois's home, and unsurprisingly, her DNA is on her knife handles. Well, I don't know. Maybe there's testimony from Mr. Cadet, who lived there with her, that she was a very fastidious person who scrubbed her knives every night. I don't know that, and I agree with you that these are strong pushback arguments, but I just think that calls on the court to maintain the line between Chapter 278 and Rule 30 proceedings, which to date it's been very vigilant about policing, and for the exact reason that we're just talking about the threshold ability to take a look at evidence that otherwise was inaccessible.
So is the calculus also only as the sword of this thing? Because I also looked at the trial testimony where, as a defensive mechanism, the Commonwealth kept arguing that she didn't stab him at all, that he stabbed himself. So does it also bear on the flip side of detracting from the Commonwealth's case, not just the first aggressor argument, but also, hey, they said she didn't do this at all. It was all self-imposed.
Oh, absolutely. Because the Commonwealth, one of the main thrusts of the Ramos case is that that forensic testing is permitted when it helps a defendant challenge the Commonwealth's trial narrative. And here, the Commonwealth's trial narrative, although in its briefing now it's saying, yes, there's no question that they both stabbed each other, that she stabbed him. A trial that was not only treated skeptically, the prosecutor affirmatively stated that's a complete lie. He did this to himself, either as a suicide attempt or to fabricate some claim. So I think that actually, so again, we're into Rule 30 territory talking about its implications on the other end, but this all just goes to materiality because it would provide forensic and underlying factual evidence to support inferences one way or the other that otherwise are only based on circumstantial evidence or the inferences that can be made from testimony. So I think that's what Chapter 278 really is about in the end of the day, is just getting more forensic facts before a court so that it can look at whether there's a more factually correct verdict available than the one that was reached at trial.
Do we ever consider cumulativeness at all in deciding whether something is material? And
I've seen it in a 278A case.
Because I'm asking, particularly in regard to the cleanup evidence, because there certainly was quite a lot of other consciousness of guilt type evidence, such as the note.
Sure, the note, the flight.
So can you explain why the cleanup evidence was actually material?
Oh, sure. Just because, again, I think I'm just going to the endless litany of cases in which this court has said that there's, the strength of the evidence at trial is no barrier to obtaining Chapter 278 testimony. So, 278A analysis. I think so. That's really the only reason. You're right. There's.
And you think that applies exactly the same to consciousness of guilt evidence?
Well, consciousness of guilt evidence in this case is a massive part of the government's case. So to say that, cumulative consciousness of guilt evidence versus cumulative eyewitness testimony, obviously the latter is a stronger form of evidence.
It's really strange here where, there's no dispute that he stabbed her. And the question is just the first aggressor.
Sure.
And one might clean up a stabbing no matter who, when you've killed someone by stabbing them to death. Is it really material on the actual issue here, which is the first aggressor issue? Who cleaned up?
Well, we talk about, so I think it is material because it's simply behavior that indicates, or at least is susceptible to argument on the basis of a person who's behaved lawfully doesn't try to clean up after themselves and hide what they did. I completely agree with you that the reality of both the way this testimony talks and these situations more generally, what we're talking about is a homicidal act between two people who were very well acquainted with each other, had an intimate relationship. So obviously, even if a person behaved lawfully, they'd probably be in a panicked and completely dissociated state. In fact, that's how he testifies to being. I didn't know what to do. I was frightened. I was terrified. So that all makes sense. And I agree with you. I think these are really interesting prejudice arguments, but I just don't think they stand as a barrier to just getting in there and seeing what these swabs have on them, and which is really the only thing that's being asked at this point, or, to do the handler DNA on the bleach bottle in that case.
Are we at the Section 3 stage?
We are at the Section 3 stage. So we're really just at with some quantum of evidence to support each factor proffered in the defendant's pro se filings. And even though, you have to sort through to find it, I would just posit that it is. Thank you very much.
Attorney Hansen.
Good morning. It pleases the court, Arne Hansen for the Commonwealth of Massachusetts. I would ask that you deny the defendant's 278A petition. One, because he hasn't demonstrated materiality, as we've been discussing today, but also because he hasn't demonstrated that this testing couldn't have been done before trial. It's something that I like to raise initially. So pursuant to 278 Section 3B5, the item needs to have not been subjected to analysis for 5 specific reasons. Now, with respect to the swabs on the knives, the defendant has not demonstrated that they were not available at the time of trial. Obviously, the murder weapons were entered as an exhibit at trial. They're certainly admissible, which goes to point 2. The defendant has to demonstrate that he wasn't aware of the evidence, certainly can't do that. These were exhibits and the testing was completed. He has to demonstrate that counsel was ineffective for failing to test the handler DNA. So that's a point that I'll return to, but point 5 is the item was otherwise unavailable, which clearly doesn't apply. So the only thing that the defendant can here do, which he hasn't argued, is say that counsel was ineffective for failing to test those swabs. So he has to demonstrate that that was measurably below what an ordinary fallible lawyer would have done, or that it would have denuded of him a defense at trial. Defense counsel in this case is in a position where his only defense is self-defense, and that self-defense claim has serious issues, which I can get into momentarily. So he has a choice. We have the blood DNA on the knives to demonstrate the victim's blood is on one knife, his blood is on another knife. Does he test the handler DNA? Does he test the handles? If that comes back as the victim's DNA is not on there, that completely destroys the self-defense claim, because it shows that the victim, or strongly supports the idea that the victim didn't touch those knives. If the knives come back and it does show that the victim's DNA is on there, well, that would certainly bolster his case a little bit, but it's an imperfect defense. So it's certainly a strategic choice for any attorney in that position to not test the knives, because it's either a small incremental gain or completely destroys his defense. So the testing was certainly available and the decision was made not to do it at the time of trial. So the defendant's 278A fails on that basis alone.
So are you saying that the testimony at trial is that on the knives, handler DNA was not tested, it was only swabbed for?
That is my understanding, but I also agree. I'm arguing it in the light most favorable to the defendant. I think your analysis of what was presented at trial is reasonable, but notwithstanding that, even if we'd say that didn't happen, and we say this evidence was tested but preserved, not tested, that's my argument, in the light most favorable to the defendant. So I think the defendant—
Commonwealth isn't able to say whether or not it was tested?
I don't want to misspeak either way. I just don't have the exact information that the court's looking for. I would have to go back through the record, and I'd have to go back through the forensic evidence as well, which I didn't do in preparation for this argument, so I don't want to misspeak. So for that reason alone—
Was that the basis of the judge's decision below?
No, but this is reviewed de novo, so we're not bound by what Judge Sullivan does. This court is in just as good a position to do it, where Justice Gaziano was the trial judge and didn't do the 278A motion. Mm-hmm. Now, with respect to materiality, the defendant's self-defense—
Before you move on to that, can I just ask you about that first part? So the IAC component, it almost starts to sound like a Rule 30 motion. So are you suggesting that as part of a 278 threshold showing that the defendant would have to get an affidavit from his lawyer saying, I thought about doing this and I strategically and made a decision to not test it because it would have impacted, if it come back positive, it would have weakened your self-defense claim? Are you suggesting that with the low threshold that we've said in case after case, or then certainly what the legislature has done, that the defendant would have to get some kind of an affidavit to explain away the strategic decisions of not getting this tested?
I think in this situation, that's the case, because in a lot of cases that we've done, we see forensic evidence that's collected, and some of the cases I reference, they recover a portion of DNA, but they're unable to test it because the technology hasn't gotten there, and therefore 15 years later, the case comes up again and they have better technology and they go deeper into that evidence. Mm-hmm. That's just not the case here. There's no new testing that this relies on. This was just testing that wasn't done or wasn't requested by defense counsel. So I think in this specific circumstance, it would certainly behoove the defendant to address the lack of, or why he didn't choose to test that.
Mm-hmm. I mean, I understood, am I wrong? I understood you to be making an argument under prong 4 that the defendant has to show a reasonably effective attorney would have sought the analysis and either failed to seek it or the judge denied it.
Correct.
And I mean, if your argument assumed that defense counsel thought the client was guilty and so didn't want to get the thing tested because it would be positive, and wouldn't that be true in almost in so many cases, like every single forensic testing case, other than where a defense counsel is himself or herself convinced the client is innocent, it is always a high stakes matter to get highly probative evidence tested because there's always a chance it'll come back positive. So how would, if that's the test, how are you supposed to meet that test?
Well, I think in this case for self-defense, I think it's better to have less information where it can substantially undermine the self-defense claim. Defense counsel is left in a position where it was clearly the only defense that he had. So I think it was a strategic choice not to test that. Again, I'm speculating because we don't have any information from.
But the statute doesn't ask about the actual counsel's reasoning for doing it, unlike an IAC claim. It just says where a reasonably effective attorney would have sought the analysis. So are you saying just in general, a reasonably effective attorney would not have sought the analysis in this case?
Yes, where it would have completely destroyed the self-defense defense.
Assuming it came back that way.
Yeah.
Correct, but the choice needs to be before, the choice by defense counsel needs to be made before he knows the results, obviously. Now, with respect to the defendant's self-defense claim, it wasn't supported by the evidence at trial. The defendant claims she came at him with 2 knives and that he was able to get one of the knives from her and then they stabbed each other. So in order for that to be true, the 9 stab wounds that the victims had would have been done with 1 knife because they're stabbing each other simultaneously. That's not what the trial record reflected. She had 3 stab wounds.
The prosecutor argue at trial the lack of the victim's handler DNA on the knives.
My understanding was that the defendant said the victim's DNA is on 1 knife, and then the prosecutor rebutted and said, well, that was her blood DNA, it wasn't her handler DNA.
So it was part of the prosecution's case.
Yes.
So wouldn't it be material if, in fact, the victim's handler DNA was on the knives, just only to rebut what the prosecutor was arguing at closing argument?
I don't see how.
Well, then why would the prosecutor have said that if it wasn't material?
I think she's saying that the only DNA that was found on the knife, the only victim's DNA was found on the knives was her blood DNA.
Right, not the handler.
Correct.
Right. I think you just have a hard time on the materiality. I hadn't considered the ineffective assistance of counsel, which is different at the Sections 3 stage than it would be at a Rule 30.
Right.
But I think given the prosecutor's argument and rebuttal of the defendant's defense, it's a tough row to hoe for you on that one at the Section 3 stage.
I understand that the bar is substantially lower here at preponderance of evidence, but even at that standard, I would suggest that the defendant's self-defense claim does not make any sense. It is not supported by the evidence, and I think that's where materiality comes in.
Point that this could further support? It would be some evidence to support his claim. Now, it could be explained away.
Right, but
as counsel has conceded. But
the fact that her DNA...
having nothing versus having something might be helpful.
I think that's a fair assessment, but I think there's a lot of evidence that counters that point. Again, the fact that her DNA would be discovered on her own kitchen implements, which...
But haven't we said countlessly, every time we have a 278A case, that the standard is not the same as Rule 30? Yes,
it's preponderance of evidence. It's a lower standard. I agree.
But you also have the issue that I see the allure of what you're saying, that ultimately this might be a fool's errand. But if the fingernails in Ramos were enough, I'm just struggling to see how this wouldn't be material, even if it's, the lightning that occasionally strikes, that why this wouldn't be in the same neighborhood as Ramos.
Because his self-defense claim isn't supported by the trial record. She stabbed 9 times with both knives. In order for that doesn't He says he stabbed her multiple times with only one knife. The claims contradict each other. There's no actual evidence that this was done in self-defense.
Well, but that depends on which trial evidence you want to credit, because he testifies that she came at me with 2 knives, right?
Right.
So I mean, if you go from there, right? Wouldn't it be material?
No, I disagree, obviously, and I don't want to keep repeating myself, but I think if she came at him with 2 knives and she was stabbed with both knives, and he says, I was stabbing her, she was stabbing me, and I stopped, she died after because she stopped, I knew she was dead because she stopped stabbing me, that part just is incongruent.
Okay.
If there are no further questions, I would rest on my brief.